Tonight on the Daily Debrief, a baby dead, a mother on trial.
She failed little Sterling.
What is her excuse?
You're not going to hear any evidence that she's evil.
Plus, testimony about blood and money in the case of a California family first reported missing, then found buried in the desert. This is the Daily Debrief for Wednesday, January 30th. Good evening, everyone. I'm here with Kenney Baden tonight, and welcome to the Debrief. Drugs and depression are an Iowa woman's official excuses for the death of her 4-month-old baby. This case is the second to go to trial, involving the alleged murder of the infant Sterling Koehn. A jury already convicted the little boy's father, Zachary. Now the mother, Cheyenne Harris, is facing a jury. The trial against Zachary ended in a conviction. Prosecutors tried him under an Iowa law which says endangering a baby to the point the baby dies is murder. Zachary Koehn took the stand during his own trial and mostly blamed Cheyenne Harris for his son's death. Harris was the little boy's stay-at-home caretaker. Here, she was led into court to hear the emotional testimony. At one point, she left the courtroom crying. This case has been a close copy of the case the state presented against Zachary Koehn. The same first responders again broke down on the stand, recalling the horrible condition of the body of the dead baby. During opening statements, the prosecutor placed blame squarely on the defendant.
The evidence in this case will show that the defendant, that child's mother, Cheyenne Harris, failed in her responsibility as a parent. She failed little Sterling. She violated the trust that Sterling placed in her as her mother. And ladies and gentlemen, the evidence in this case will show by her actions, Sterling lost his life. Ladies and gentlemen, the actions of the defendant that you'll hear in this case will show that she placed little Sterling in the back bedroom of that 2-bedroom apartment in Alta Vista. She placed Sterling in a swing. Sterling laid in that swing. He laid in that room in a diaper that hadn't been changed in as many as potentially 14 days. Somewhere between 9 and 14 days, his diaper hadn't been changed.
The prosecution continued by saying the defendant did not have an excuse for Sterling's death because her other child was just fine.
This is not a case where the parent, Ms. Harris, lacked resources or was an inexperienced parent. We're going to hear, ladies and gentlemen, that her live-in boyfriend, Mr. Koehn, he had a full-time job. He worked at a trucking company, and he earned a salary of $45,000 per year. You're also going to hear, ladies and gentlemen, that that other child in the home, her name is Nala. She was only almost 2 years old. The evidence will show that she was healthy, in contrast to Sterling. In contrast to Sterling, she was properly clothed and clean and bathed. She was properly fed. But this case is about actions and consequences. Actions and consequences. The actions of the defendant in this case directly caused the death of her child, Sterling Koehn. That was the consequences.
The defense is open and lasted about 1 minute. Cheyenne Harris blamed mental health issues, depression, and drugs for her little boy's death.
There's no doubt that this case is a terrible case. It's a tragedy. You're going to wonder what kind of monster would do something like this. The monster in this case is mental health. The monster in this case is depression, postpartum, substance abuse. You're going to hear evidence in this case about Ms. Harris, what she was going through, how she suffered from depression, how she suffered from postpartum, and how she self-medicated. You're not going to hear in this case about the typical type of actions you might hear when you hear about child abuse. You're not going to hear about injuries. You're not going to hear about broken bones. You're not going to hear about bruises. You're not going to hear about any purpose on Ms. Harris's part to harm Sterling. You're not going to hear about any evil design or any plan or any ill will towards Sterling. You're not going to hear any evidence that she's evil. That's because she's not evil, and this case is not murder.
Some people might debate that, though. Joining me tonight for analysis on this case is the preeminent criminal defense attorney, Kenney Baden. So,
nice to be on. I'm so excited to be on with you.
Okay, so let's break this down here. That was a short defense open. They were trying to humanize her, but I'm wondering, what's the real audience here? Is it the jury or is it the appeals court when they try to say she didn't have the right mental state?
No, I don't know. I kind of thought the opening was good. I liked it, actually, because the case boils down to whether she can prove. Remember, it's an affirmative defense. That means the defense has to prove that she had postpartum depression, so it took away the ability to have that intent to murder that child, to take those actions.
Okay, so they take that away. What happens then?
If they take that away, she gets convicted of manslaughter or aggravated manslaughter, whatever the lesser included offense is in Iowa, and she goes to jail. And she absolutely goes to jail. It's not like Andrea Yates, where she went to a psychiatric institution because it's an insanity defense.
But she gets some punishment. That's the bottom line.
Yeah, she gets punished.
If the jury buys this. I don't see the jury turning around saying, here, let's acquit her.
Here's the problem I have with it. I think postpartum depression, we know, is a serious issue in this country. 15% of the women have it who give birth in the first year. Lesser numbers for psychosis. But she's taking care of the other child, and the dog, and her husband, and herself, and making grilled cheese. So somebody has to explain to me, if I'm on the jury, how that can happen.
Exactly, and I was sort of leaping a couple of thoughts ahead there, because that's where my mind went as well. I thought the prosecution sort of took the air out of that argument before the defense even got there.
Right. Now, and that's the problem the defense has. No doubt she had postpartum depression. She had it with the first child, but she didn't take the medicine. No doubt there was problems there. No doubt the father could have stepped in. But the problem is the mother's also responsible unless it takes away that intent.
It's a pretty easy law to get a conviction under in Iowa in this case. There's a specific subsection of the murder statute that says if it's child endangerment resulting in a death, it automatically leapfrogs to murder.
Yeah, and that's the problem here, and it's such a terrible case, terrible facts. And the sheriff's office, the deputies, they were just fabulous in how they investigated it.
Yeah, we're going to go exactly in that direction right this moment now. Sterling's father called 911 to report Sterling wasn't breathing. The nurse, who was the first to arrive at the scene, testified about trying to perform CPR, but she said it would have been pointless.
It was dark and it was stuffy and there was a stench of urine there. I was looking for a crib. I couldn't see a crib. I said, "Where's the baby?" And he said, "In the swing." And it was dark. I said, "We've got to get some lights on in here. Turn the lights on." And he flipped the switch and the lights came on. And he walked away and he muttered something, and I don't know what he muttered. I went over so I could see Sterling, the baby. Found out that's what his name was. And to do my assessment, look, listen, and feel, his eyes were fixed and dilated, staring straight out. He had blood around his mouth, and I went to check a brachial pulse on him, and his arm was stiff and rigid and cold. All of his extremities were cold. His little feet were cold. His hands were clenched in a fist. And he wasn't breathing. And his clothes were like crusty.
When you saw Sterling, did you know that there was nothing we could do?
Yeah, there's no CPR. It just wasn't right.
A letter carrier went on to testify that the nurse had trouble finding the right apartment when that nurse first arrived. The letter carrier refused to look, but heard the defendant say something very important.
Did you see the baby?
No.
Why not?
Because she wasn't performing any care, and I didn't feel I needed to have those memories.
So you chose not to look at the child?
Correct.
What happened next?
Tony said I should just console the parents. So I turned around and they were standing right outside of the bedroom. And I went up to them and told them I was sorry and what had happened. And she said that the baby was fine last night at 9:30 when I fed him. I said him, and he said, yes, Sterling. I said, do you mean this morning? And she said, I don't know.
How was Cheyenne Harris, her emotional state when you talked to her?
None. There was no tears. There were no emotion.
Did that reaction seem strange to you?
Yes.
Why?
She should have been crying and screaming and upset.
There was a very difficult to hear objection there that we cut out, but the bottom line is the judge allowed that testimony to continue from that letter carrier. Still ahead tonight here on the Daily Debrief, we head back to that case where a family of 4 turned up dead in shallow graves in the Mojave Desert. Questions linger about what prosecutors say was the defendant's motive. Testimony about money and blood when we come back after these messages. Welcome back to the Debrief. A preliminary hearing has been delayed for the former college president accused of playing a role in the Larry Nassar sex assault scandal. Luanna Simon faces charges that she lied to investigators about her knowledge of the accusations against Nassar. Next week's hearing will determine if prosecutors have enough evidence to move the case forward. Nassar pleaded guilty to federal and state sexual abuse charges after more than 100 gymnasts came forward against him. Now to the case of a California man accused of murdering a family of 4. Testimony there is on hold while the jury takes a field trip to see important locations related to the testimony. Defendant Charles Merritt could face the death penalty if convicted in the killings of business associate Joseph McStay, McStay's wife, and the 2 McStay boys. First, the McStays disappeared. Then, authorities said they may have fled to Mexico in this video to avoid debts, but that turned out not to be true. The family turned up years later, buried in the desert. Prosecutors charged the defendant, saying he killed for money. For months, the state promised it would present evidence that the victims were killed in their home. Here's the problem. There's no conclusive evidence of blood in the home. The state has presented pictures of tiny droplets of suspected blood, possible blood. The police testified they didn't even notice these spots until they took their photos back to the police station and enlarged them. By that point, relatives had cleaned up the scene and any evidence was gone. Therefore, no one is really sure just what those spots are. The state tried to clear that up by asking a medical examiner if the brutal attack with a hammer would have left blood behind at the scene. Here is her opinion.
Now, could an injury like this occur without there being any actual blood that comes out on the outside of the skin?
Yes.
How could that occur?
Because you will have blood coming out of the skin if there was a laceration, an open wound. With a trauma like this, you're definitely going to have external injuries, but it could be a bruise or an abrasion. It doesn't have to be a laceration.
How about some of the other fractures that we looked at with respect to Summer McStay? Is it possible for those injuries to have occurred without external lacerations?
Based on the number of pieces of skull that are broken, you would expect that there would be some lacerations, but not all of the skull fractures need to have an overlying laceration.
Is it possible you could incapacitate somebody to a certain degree without causing a laceration to the skull with blunt force trauma?
Yes.
So, it's the medical examiner's opinion that despite the condition of the family's remains, despite the injuries, that the wounds they suffered might not have caused a lot of blood loss. The defense fought back against that.
With this type of this reconstruction, I guess, to the skull, as they're saying, you'd expect to see laceration.
With this type of trauma resulting in multiple pieces, I would expect lacerations on the scalp.
And for premature, skull was, I guess you'd say, shattered.
Yes.
And this again would lead to the same type of excessive bleeding that you described with Joseph McStay.
It would lead to a pooling of blood, such as Joseph McStay.
Now the expert is saying the injuries would likely have caused blood to pool. Let's move on to the alleged location of the crime. Why did prosecutors promise the murders happened in the McStay home, despite the lack of blood? The answer might involve a bathroom floor mat and some towels.
You, as an initial investigator, evaluating the state of the investigation when you saw that photograph?
And that there were no towels inside the bathroom.
Okay. And is this the downstairs bathroom?
That's correct.
Exhibit number 100. Is that the upstairs bathroom?
Yes, the upstairs shared bathroom.
And what was significant about that photograph when you reviewed it?
Again, no towels.
Exhibit 660 in the top left. That is what?
That's the master bathroom, and there's one hook with no robe, and then a second hook with a bathroom on it.
In the bottom left, exhibit number 53, what is that?
That's the downstairs bathroom toilet, where there's a decorative rug chamois on the toilet seat, and no matching floor rugs or any other type of matching set to it.
Did that cause you to look at the evidence that was recovered from the grave sites?
Yes.
Showing you exhibit number 297 as displayed. What was significant about that?
Looking at the fabric and the way it's depicted in the photograph, it appeared consistent with what would be either the bathrobe, if there's one missing from the hook, or from matching rug to the toilet seat cover.
We'll dive into that more in a little bit here, but also the state has argued that defendant Charles Merritt killed the McStay family over money. The two worked together building waterfalls and fountains. And one of the defendant's former employees testified that the defendant, Merritt, did a project using some of victim Joseph McStay's inventory. Here's how the defense dealt with that.
Projects did Joseph and Chase do together while you were there?
Many.
What would you say? More than 3?
Definitely more than 3.
More than 10?
Yes.
20?
Many.
Was it more than 20, do you think?
Yes.
And these were all waterfalls that were built by Chase himself, correct?
And the employees, yes.
And how many other employees would help?
At some point there were three or 4.
But they did all the building?
Yes.
If I understand, your other testimony is that there was an occasion where payroll was not going to be made, is that correct?
Right.
Okay. And so Chase told Joseph that there was a waterfall that was completed, is that right?
Yes.
And do you know which waterfall that was?
No.
Do you know how much it was worth? Because you said they're different values, right?
Mm-hmm.
Okay,
yeah.
so, but you said you called Joseph and told him about that, right?
They had a conversation regarding...
Well, my question is, did you call Joseph and tell him that?
Tell him what?
That the waterfall wasn't completed?
Yes.
Okay. But you must have told him which waterfall it was.
Yes.
Which one was it?
Objection argument, asked and answered.
So you don't know which waterfall it was?
Objection, asked and answered.
And you don't know the value?
Objection, asked and answered.
But Chase was trying to get the money from Joseph to cover payroll, including yours, right?
Objection, speculation, misstates the evidence. Overruled.
Correct?
Yes.
We have a lot to talk about here. Attorney Linda Kenney Baden, I'm trying to figure out what's going on with these objections and more particularly the judge's rulings. Right. Because, look, it's common defense work to sort of chip at somebody's story and then try to line it all up logically and ask the questions in a similar way. Look, I get the objection I get that the state didn't want to try to force her to backtrack and say, yeah, I thought he used the dead guy's equipment, but I can't really remember much about it. That's what the defense wanted. But
right.
Look, I mean, should the judge have just let that go on?
This is a death penalty case. All this is going to get reversible error if he gets convicted. Because let's face it, I mean, the objection to the jury, you know what it looks like? The prosecution doesn't want me to hear it. Why is the prosecution objecting all the time? You got to be very careful when you object in a trial. It has to be for something really important, not this.
You know, I look at these sometimes and say, okay, look, I understand the rules of evidence. I understand the objections, but the rules of evidence in a case like this are meant to serve the bigger constitutional purpose of allowing a defendant to present his defense. And if that doesn't get done, then we've lost the forest to look at a particular tree.
Let me tell you, the juries know that. They know that. This whole common sense with you talked about before with the blood, you know, that you don't get blood. Anyone who's had a head wound knows how much a head wound bleeds, right? They know that.
Yeah, the capillaries are close to the surface, and everybody knows that.
Everyone knows that. So the jury's going to use their common sense. They're going to use their logic. They're going to say, put the nonsense there. Is there evidence here? And we can't just kind of fit evidence. And I don't know, it starts with the murders had to take place in this house. Why?
Well, okay, what about the towels? Do we buy this theory that one of the rug on the toilet cover matches the scrap of fabric that was found in the grave?
No, there's no scientific evidence of that. Some investigators say, no, I think that could be. There's simply none. You can't even match the paint here.
I mean, how many thousand toilet covers are sold in Southern California on a daily basis?
Yeah, this is like El Chapo. I mean, this woman has got the bra cut. I mean, I feel like I'm in an El Chapo drug case. I don't feel like I'm in a Chase Merritt. You know, he may be guilty, but that's not the feeling I'm getting right now in this prosecution presentation.
In other words, the state's not holding to its burden.
Right.
Okay, we got the money back and forth, too. We could go on that forever. You know, bottom line, these two had money trading back and forth. I'm not seeing a smoking gun.
I'm not seeing a smoking gun right now. I'm not seeing conviction. That doesn't mean he's not guilty, okay? But I would have waited on this case.
Linda Kenney Baden, I appreciate your opinions as always.
Thanks,
come back
Aaron.
anytime.
Pleasure.
It's all the time we have tonight on The Debrief. I'll see you back here at either 4 o'clock or 5 o'clock on the network, depending on testimony in the McStay family murder case. It's time to sign off for the evening. Live trial coverage picks up tomorrow at 9 a.m. Eastern. Have a good night.